Good morning, seniors. I'm Chuck Austin. I'm with the NCRO Insurance Committee, and I'm kind of your host or moderator today. Just in case you're a little confused like some seniors are, it's Wednesday the 18th of 2020. It's around 11 o'clock in the morning, and you're signed up for a webinar on estate planning in the new strange world that we live in. I want to cover a few clerical details first, and then I'll introduce our speaker. We've got more than 200 people signed up, so quite a few could be online today. This presentation is going to be about 60 minutes in length, plus or minus. It depends on how many questions we have. You're going to get a thank you questionnaire afterwards from Dale Cook. So if you have questions, you can ask them through that questionnaire. Also, we plan to send a survey out in the next day or so after the webinar. And again, we'll be asking for comments and questions in the survey. The slides for this presentation have already been posted at the NCRO website, and the video will be available in a few days too, in the aging section of the NCRO website. So as I mentioned before, we're here to learn about estate planning for our strange new world. We're going to talk about wills and trusts, especially reflecting recent laws and the COVID world we live in. And we're very pleased to have as a speaker Diana Moak. Diana has spoken to us before. She's a partner in Pugh Moak, a law firm that specializes in family law and estate planning, special needs planning, elder care, advocacy, and so on and so forth, long-term planning. Diana also is involved in the Hyatt legal plan. So if you are a Chrysler retiree and you have the legal plan, you can consult with Diane at a very reduced rate. So with that, Diane, it's all yours.
Well, hello. I'm glad that you could all be here today. It is estate planning for our strange new world. So it's obviously COVID, but also we've had the election and we've had some changes in the law. So there's a lot for us to talk about today. Yeah, I'm not moving forward. There we go. Okay. So I want to start off by saying, first of all, that normally when I'm presenting to you, I'm in Troy and we're all sitting in a big room. And I know that pretty much you're all from Michigan, but this time, since we're doing this virtually, I've actually already gotten a call from someone in New York with questions about this. So just so that we're all clear, I'm only licensed in Michigan, and what I'm talking about is mostly Michigan based. So I will be talking about some federal issues like the federal estate tax, but for the most part, everything that I'm saying you should assume is based on Michigan law. And as part of the Hyatt legal plan, which you may have, and it's now called MetLife legal, I believe, you can call an attorney in your state and find out, is this the same? Is there anything different about this? I was in this online seminar and this person from Michigan said this, and they'll be able to give you advice about what is appropriate in your state. So that's just my disclaimer right there. These are the things we're going to be talking about today. So normally when I do this, I start off with going through the basic estate planning documents, but this is my third presentation with you, and I think that maybe some of you have been to all three. So I want to start really with what's new and what has changed and what you should be changing, but we will get to all of the documents that you should have as part of your estate plan as well. So we'll start with what's new, then we'll go to what COVID has changed, which was a bit of a surprise. Then what do you need to change? Then we'll get to what documents you should have as part of your estate plan, what resources are available to you, and if we still have time, I'll give you a little bit of a Medicaid update. Chuck said at the beginning that I do family law. family law is sort of a term of art, which means divorce, which I don't do. So please don't consider me for that. For Medicaid, I give advice about long-term planning, but I'm not VA certified, and I don't do the Medicaid applications or the appeals. I help you plan for the future more than anything else. So that's the type of advice that I'll be giving you, not the specifics about how to appeal or what your application should say. Oops. Sorry about that. Let me move on to the next one. So what's new? Our federal estate tax exemption right now is 11.58 million. And I say right now because that's what I mean. We've had an election. And as part of Joe Biden's platform, he is talking about reducing the estate tax exemption amount. Right now, each person in a couple, so if you're a married person, each individual can have 11.58 million and not pay any taxes. And if that person leaves everything to their spouse and the spouse files an estate tax return claiming the deceased spouse's unused exemption, then the second to die can have 23.16 million now and not pay any estate taxes. This is scheduled to go back down to about 6 million in 2026. It'll be a little more than 6 million because it's adjusted for inflation each year. But also with the Biden administration coming in, we're expecting some changes here. So with Trump's tax cuts, he basically doubled the exemption. And so for a few years now, it's been twice as high as it was at the end of the Obama administration. And so it would be pretty predictable that the estate tax exemption would go back down to about what it was during the Obama administration. So somewhere in the area of 5 to 6 million per person instead of the 11.58 million per person. Some people are saying, and I think that it was part of a written tax plan that Joe Biden put forward, that he wants to bring the exemption down to 3.5 million per person. But don't forget that he's going to need Senate on board to do that. And the senators are self-interested. So I think they are very unlikely to bring the estate tax exemption down so low that their own families would need to pay estate taxes. So although I think it's fairly likely that the exemption will go down to the 5 to 6 million per person, I do think it's unlikely that it's going to go down any lower than that. So does your state have an estate tax? Michigan does not. So you can see Michigan's light gray and most of the country is. And that means that those states don't have estate or inheritance taxes. So the states that are light blue, those are states that have inheritance tax. And so what that means is that when you leave money to the people in those states, they may have to pay taxes on it. Then there's also the purple states. Those states have a separate estate tax. So although the federal estate tax exemption is the 11.58 million, you can see that in New York, the estate tax exemption is 5.9 million. So a person who might not have to file a federal estate tax return might need to do a state of New York estate tax return. So that's less important for us in Michigan, because we don't really care if the people in other states have to file estate taxes. What we do care about is if our kids who live in other states are going to have to pay taxes on what they inherit from us. So as you can see, the people who are living in Nebraska, Iowa, Kentucky, Pennsylvania, New Jersey, and Massachusetts, oh, I'm sorry, that's not Massachusetts, that's Maryland, are going to be paying more in taxes. Maryland is the one lucky state left that has both an inheritance tax and an estate tax. New Jersey was that way until last year, but now they've finally updated to get rid of their estate tax. Now they only have inheritance. This is something new in Michigan. It used to be that if it was your intention to disinherit a child so that you were not naming one of your children in your documents, your attorney might have told you that you should at least identify that child and say, I'm aware that I have this other child, but I don't want him or her to get anything. Michigan courts then came through with a really weird decision that said that even if you're not leaving your child anything in your estate, and even if you don't have an estate, if you just have a trust, under Michigan law, that child who you didn't leave anything to was entitled to about $15,000 in either personal property, or if you didn't have that much personal property, cash. And so our legislature responded to that decision and came up with a statute that says that now if you do reference the statute or specifically state that you don't want for the child to get any of these exemptions or probate allowances, then you can fully disinherit a child. But it's harder to do than it was in the past. And so you should review your documents if this is something that you're trying to do. The Secure Act is also new, and this came in last December when everybody was looking the other way. So we were all focused on the impeachment, and lo and behold, Congress passed a law that actually affects a lot of us. And so what the Secure Act says is that most beneficiaries who inherit IRA, 401k, 403b now have to take the benefits from that plan over 10 years. So it used to be that your beneficiaries could elect to stretch the distributions out over their entire lifetime. And they would then have to take out just a little bit each year based on the required minimum distribution. Now, most beneficiaries won't have required minimum distributions, so they don't have to take anything out in the first year or the second year. But by the end of the 10th year, most beneficiaries have to take out everything from an inherited IRA, 401k, 403b. So there are certain beneficiaries who don't have to do that, and we'll talk about that more in a later slide. But just be aware that the Secure Act affects your beneficiaries, and it might not be better anymore necessarily to name a younger beneficiary. Funeral representative designations are also new-ish in Michigan. So I have talked about these with you before. They came in 2016, but until 2016, you couldn't say in Michigan who you wanted to make funeral and burial decisions for you. So no matter what you did, even if you prepaid, your closest living relatives got to make your funeral and burial decisions. And so if you weren't married, but you had a partner who you'd been with for decades, that person had no standing in burying you. It was your sister who lives in Montana because she was the closest living relative who got to decide. So this is a good change, I think, for Michigan, because now if you've got a close family member who disagrees with you, maybe you have a close family member who's very opposed to cremation, but you really want to be cremated, now you can name a funeral and burial representative, and that person will have the authority to make your arrangements for you. They can still undo whatever you've already done. So if you have prepaid, your funeral and burial representative can undo that. So you just want to be sure that you're naming somebody who will follow your wishes, and then you probably also want to name a successor so that if the first person you're naming can't act for any reason, you've got a backup plan. What did COVID change? Well, obviously we weren't expecting COVID, and I've got to say my father-in-law always says he's busier than a one-armed paper hanger with an itch. And I think he's got to change his saying to he's busier than an estate planning attorney during a pandemic, because we're busy. Everybody's thinking about us. And unfortunately, more people are dying as well, not necessarily from COVID. I've personally had about 8 clients die from COVID, but I've had a lot of clients die because they didn't get the medical treatment that they should have gotten because they were afraid to go to the doctor or they didn't want to go to the hospital. So I have had more clients than usual dying this year anyway. One thing we've learned about COVID is that springing durable powers of attorney are difficult. So I'm going to go to the next slide just to show you this. This is a typical springing durable power of attorney. So we'll talk about powers of attorney in more detail in a later section. But basically, a springing durable power of attorney is saying, I want someone to be able to do everything for me that I could do for myself, but not right now. So I want my daughter to be able to do my banking for me. I want her to be able to sell my house for me. I want her to be able to enter into contracts for me, but not while I can do it myself. I don't want her to be able to call up the bank and find out how much money is in my account. In those cases, in the past, we had always done these springing durable powers of attorney that spring into effect when your agent has letters from 2 doctors, like highlighted in that red box, showing that you're not able to act for yourself. And sometimes these were mutual, like the one that I'm showing you now, where a husband and wife are both designating one person to act for them when they can't act for themselves or for each other. And sometimes they're just individual, where you're just naming one person to act for you when you can't act. But the long and short is that COVID has made these difficult, because it's very hard to get in to see doctors, let alone to contact somebody else's doctor and get them to write a letter saying that that person isn't able to act for themselves, because doctors aren't anxious to write those letters anyway. So that's been a problem, and more of my clients have gone to the immediately effective powers of attorney, and it might be something that you want to consider. Another thing with COVID is your RMDs, your required minimum distributions. So you probably have heard that the CARES Act said that you don't have to take an RMD this year. So it's okay if you can just let your IRA 401k grow. However, if you do want to make the gifts to charity and you were using your RMDs to make gifts to charity, you can still do that this year. So you can still make charitable gifts from your IRA, even if you aren't required to take out a minimum distribution this year. So just keep that in mind if that's something that you'd like to do. Remote signing. This has been a nightmare. So you probably don't know, but until COVID, if you wanted to sign your estate planning documents with me, and they've got to be witnessed and they've got to be notarized, you had to do that in person. So there really wasn't a way of signing remotely before COVID. We had some services, like I could send a notary to your house and they could notarize it, but it was all in person. So DocuSign was not a thing in the estate planning world. And to a huge extent, it's still not a thing in the estate planning world. In March, the governor entered some orders saying that we could do remote signing, but it was very, very cumbersome. We would do it through Zoom or through FaceTime. You had to hold up the document. You had to tell me who you are, tell me you're in Michigan. You had to tell me what you were signing. Then I had to watch you sign it and be able to see your face and your hand while you're signing. And then you had to hold it up after you sign. And then you had to email it to me before midnight that day. And then you had to mail me the regular document within 24 hours. So that's very, very cumbersome. But still, it worked a little bit. Then the Supreme Court called all of the governor's orders into question. So attorneys were very worried that our documents that we had witnessed remotely, even deeds that had been recorded, were of questionable validity. So we were very worried about that. Our legislature did come up with an order. And so now remote signing is authorized under statute in Michigan, but only from April 30th, 2020 through December 31st, 2020. And a weird thing about that is that we had clients signing remotely under the governor's orders before April 30th. But the statute only says that anything that was signed between April 30th and December 31st is valid. So we also don't know what's going to be happening in January. We don't know if this will be extended. We don't know if there'll be a new statute. So I would say, if at all possible, if you do need to sign a legal document, it's much better to make the appointment, go to the bank or go to your lawyer's office and sign it in person, get it witnessed and notarized, wear your gloves, use your hand sanitizer, wear your mask, socially distance, be careful, but that's the only way that we're really sure that the documents are going to be honored as valid for the future. That's the springing durable power of attorney that we talked about. What do you need to change? Well, for secure, there are planning opportunities. So it used to be that if I had a client with a beneficiary with special needs, I would tell them to leave all of their IRA and 401k assets to their other kid, to their typical kid. And we would leave life insurance, or we would leave bank accounts for the benefit of the special needs child through a special needs trust. That has turned completely around. So now your typical child would have to take all of the assets out of your IRA, 401k within 10 years. But your special needs child can still stretch the distributions over their entire lifetime through a trust. And so there are special eligible designated beneficiaries who are still able to use the lifetime stretch under Secure. Those are your spouse, someone who is not more than 10 years younger than you. So before, if you had come into my office and you said, I want to leave everything to my brother and my sister, and they're about my age, we're all in our 60s, I would have said, do your brother or sister have any children? Because maybe the IRA assets should go to the children instead, because if they're adults, they could stretch out the distributions over their lifetimes, which would defer taxes longer and save taxes in the long run. Now that calculation has also changed. So now if you do want to leave assets to your brother and your sister, and also to your nieces and nephews, it might be better to leave the IRA and 401k assets to your brother and sister if they're not more than 10 years younger than you. So not more than 10 years younger than you also means they could be older than you. So it's sort of awkwardly written, but anyone who is an IRA beneficiary who's not more than 10 years younger than you can also now stretch out the distributions over their whole lifetime. Your own minor child can also stretch. So if you do have minor children, they can stretch the distributions out over their lifetime, but only until they become adults. And this is a really fuzzy area under Secure. We don't have our regulations yet, but there's some language in Secure that makes us think that a person stops being a minor when they're 18, that they stop being a minor when they're 21, and possibly even that they stop being a minor when they're 26. So if you were to leave IRA and 401k assets to a minor child, you would probably do that through a trust. And your trust now does need to have some different language in it too, so that your kids can be able to stretch that out longer. But then, for instance, if you had a 17-year-old child, and if it's determined that the age is 26 when they stop being a minor, they would be able to take advantage of that lifetime stretch from the time that they're 17 until they're 26. So maybe they're only taking 1/40th of the IRA out each year at that point. But then once they become an adult, which for our example is at age 26, then they would have to take the remaining assets out over only 10 years. But again, this only works with your own minor child. So not a stepchild, not a grandchild, your own minor child. Another person who can stretch for their whole lifetime still is a disabled or chronically ill beneficiary. And in Secure, these are defined in two different ways. And so one of them has more, I think it's disabled, has more to do with ability to work, and chronically ill has more to do with ability to do the activities of daily living. So you would want, a person might qualify as being disabled, but not qualify as chronically ill, or vice versa. So if you did have an issue where you weren't sure if your child would qualify under one definition, you might want to look at the other definition and take a look, even if you don't think of them as being chronically ill. And so those beneficiaries can also stretch over their lifetime, even if the distribution is in a special needs trust. And then a spouse. So it doesn't matter how much younger your spouse is, your spouse can also stretch over their lifetime. Everybody else is stuck with that 10-year stretch, which does give them a little bit of flexibility, that they don't have to take required minimum distributions and they don't have to amortize it strictly over the 10 years. So for instance, if you had a daughter who was thinking about having a baby and she wanted to take a year off of work, she could elect to take your whole IRA in that year that she's taking off of work to replace her income, so that then she is having to pay taxes on what she gets, but she also is able to sort of replace the income that she didn't get by staying home that year, so that then her tax situation doesn't change too drastically as opposed to when she was actually working. When should you check your documents? Well, I normally tell my clients that they should read their documents every 3 to 5 years and make sure that they still say what you remember. So you might think that you've named a certain person as your agent under power of attorney, or that you have your medical decision makers in a certain order, but you might have forgotten and you might have it twisted. So you just want to look at your documents, make sure that they still say what you want. You should also check your documents if you refinanced. So all of my clients are refinancing this year. The mortgage rates are so incredibly low. But what that means is if we've done enhanced life estate deeds, a lot of times the banks are telling my clients that they have to undo the enhanced life estate deed and quit claim the property back to themselves, so that then it's just in their names, even though it was really just in their names anyway. And so if my clients do that at the closing and they don't then let me know and do another enhanced life estate deed or deed the property to their trust afterward, then that property is going to have to go through probate. So even though they had done the right thing when they signed their documents, if they refinance, take the house out of their trust, or undo their enhanced life estate deed, they may wind up having to probate if they don't fix that after they close on their refi. If you want to leave assets to charity, you should look at your documents. It might make more sense to name your charities as a 1% or a 2% or a 5% beneficiary of your IRA instead of in your trust. So the trust is primarily post-tax assets, so the assets that you've already paid taxes on, like your brokerage accounts. And your IRA assets, if you leave those to a trust, nobody ever pays taxes on those. I'm sorry, not if you leave those to a trust. If you leave those to a charity, then nobody ever pays taxes on those because you didn't pay taxes yet. It's still in your IRA. When you give it to the charity doesn't pay taxes either. So if you do plan to leave assets to a charity, the IRA is really the best way to do that. If you want to disinherit a child, you want to review your will, like I talked about earlier. And have you updated your documents since 2012? So in Michigan, that's when we had our most recent significant law change, and that's when the new power of attorney code went into effect. So your powers of attorney that you signed before 2012 are still okay, and the statute specifically says that, but the more time that passes, the more the documents are likely to be questioned if they don't meet the 2012 requirements. So, you know, it's like if your agent is taking your power of attorney to the bank and trying to access your account, if the teller didn't work there before 2012, they only know what the 2012 documents are supposed to look like. So if they're seeing an older one, they might question it. It might have to be sent to their legal department. It's just probably better to update your documents if you haven't done anything since 2012, at least your powers of attorney. Have you checked your beneficiary designations? Now, this is a big one because we've had so many situations where our clients have had beneficiaries designated, but then when they died, the bank says they can't find a beneficiary designation, or they don't have a record of the beneficiary designation. And this happens a lot when the banks merge. So if you have your accounts payable on death to a person or payable on death to the trust, you want to double check, especially if your bank merges with another bank, to make sure that that beneficiary designation is still in effect. For your life insurance and your IRAs, you want to be sure that those assets are going have a backup beneficiary. So you've probably got a primary beneficiary named, but you might not have named a beneficiary in case your spouse dies before you. You might not have a backup beneficiary named. And so if you didn't have a backup beneficiary named and your primary beneficiary died, then you'd have to go through probate. You also may not have thought to designate a beneficiary on your checking account. So a lot of my clients that have trusts don't want to put their checking account in a trust because it's too much hassle and it's joint and they want their spouse to be able to access it and it's just in and out and they don't think it's a big deal. It's really easy to make that payable on death to your trust, and that way there wouldn't have to be any probate. So I would recommend that you try and do that. It's just a matter of going into the bank with the other account holder, if it's a joint account, and signing a beneficiary designation to say that the account will transfer on death or be payable on death to your trust or to another person. These are typical beneficiary designations: your life insurance, your IRAs, 401ks, 403bs, your bank accounts, HSAs. It seems that just about everyone has different rules about their HSAs and who can be beneficiaries. But you really do want to be sure that you have a beneficiary designated on your HSA, because you might have more money accumulated there than you realize. And oops, I've got bank accounts on there twice, but I guess I don't mind having bank accounts on there twice, because that's just what people forget. It's easy to remember to do the life insurance, easy to remember to do the 401ks, because you're prodded to designate beneficiaries. But most of my clients don't have beneficiaries named on their bank accounts until it's suggested to them. So even if you don't think that you need a full estate plan, maybe you don't need a will, maybe you don't need a trust, and you can avoid probate by having beneficiaries designated on all of these assets, and also having an enhanced life estate deed, which we'll talk about later as well. So those were the ways that you would avoid probate without having an estate plan. But what if you want to leave money to your grandchildren and your grandchildren are minors? Or what if your children aren't all good with money? What if your kids might divorce? What if you want to leave money to lots of different people? Or you want to be really clear and have a backup plan if one of your beneficiaries dies before you? And especially what if someone has special needs? Then you really need an estate plan. You don't just want to die intestate and have everything go the way that the statutes say. So the state of Michigan does have a plan for you if you don't have a will. And what that is that your assets would go to your closest living relatives. It doesn't mean that everything would go to your spouse if you die and you're survived by a spouse. So if you don't have a will and you want everything to go to your spouse and you have children, then you just need to be aware that assets that are in your own name, not joint with your spouse, would be divided between your spouse and your children once they reach a certain point, and they wouldn't all just go to your spouse. These are the documents that are in a typical estate plan. So you have a will. Whether you have a trust or whether you don't have a trust, you should have a will, because that's at least spelling out who's going to get your assets and who you want to be in charge. If you've done a really good job with your beneficiary designations, and if you do want all of your assets to go to your kids if you were to pass, then, you know, sure, you can get away without having a will, because we don't want your will to be probated anyway. But you really need to stay on top of your beneficiary designations. And you need to make sure, especially if you want for your assets to go other than the way that the state would divide them, then you need to have a will too. If you have a revocable living trust, then that's saying how your assets pass, and that's avoiding probate. The assignment to trust is what puts your assets that don't have their own titles, like your couch and your dog, puts those things into the trust so that those things don't need to be probated. A list of personal property is where you would say that you want your ring to go to your niece and you would like your lawnmower to go to your next door neighbor. So you don't need to update your trust or your will to specify those things. Under Michigan law, we have a statute that provides that if your will says or your trust says that you might make a list of your personal items and who you want them to go to, that list is enforceable as though it was part of your document. And you can change that as often as you want without going to an attorney. You just need to sign it and date it. The enhanced life estate deeds are important. These are a way of avoiding probate, and it's also a way of qualifying for Medicaid without having your house in your trust. So enhanced life estate deeds are also called ladybird deeds. What they really are transfer on death deeds. So what they're doing is reserving a life estate for you, and then saying that on your death, if you still own that property, you want that property to go to your trust, or you want that property to go to your daughter. You can designate who the property goes to, and you can also change it anytime you want without telling those people. So it's not like adding a joint owner on the property. It's still your house, and you can change the beneficiary as often as you want. You just need to file a new deed doing it. So that's a very flexible way of transferring real estate. But again, that's something that the mortgage companies don't love, and a lot of my clients have had to take their property out of their enhanced life estate deeds in order to refinance. Everybody should have a general durable power of attorney. This is the most important document in your estate plan. And this is what's saying who can do things for you if you can't do them yourself. If you didn't have a power of attorney and you were to suddenly be unable to act for yourself, maybe you're in a coma, maybe you've been in a car crash and you're not awake, nobody would be able to make decisions for you without that power of attorney. And in fact, the hospital would require that someone be appointed as your guardian. So we want to avoid that. We don't want your family members to have to rush to the probate court to get orders appointing them as guardian so that they can make decisions for you. You want to designate who you want to be making decisions, and you want to be authorizing them to do certain things, not everything. So maybe you want to authorize them to take out the required minimum distributions of your IRAs for you, but you don't want them to be allowed to change your beneficiaries. That's the type thing that you say in your power of attorney. The springing durable power of attorney we talked about earlier, that's been a little bit problematic during COVID, but it still has a role. So if you really want your spouse to be your general durable power of attorney, or you've got a trusted child who you really want to be your general durable power of attorney, but you've got a backup person who you really don't want to have access to your assets right now, and you really don't want them to be able to contact people and claim that they're your power of attorney. Maybe you want them to have a springing durable power of attorney so that they could act for you if you are in that coma situation, but they can't act without having letters to prove that they're authorized to act. So usually this is triggered by 2 letters from a doctor saying that you're unable to act for yourself. You can create any trigger that you want. You could say that it's triggered when a majority of your children vote that you're not able to handle your own affairs any longer. But maybe your children would vote that right now. So you want to be careful on what your trigger is and make sure that it's something that you're comfortable with. Your patient advocate designation is your medical durable power of attorney. You've heard of living wills, but Michigan's not a living will state. So in Michigan, you sign a medical durable power of attorney, which is frequently called a patient advocate designation. And what that is that's designating a person to make medical decisions for you. I like for you to also have 2 backups, because if the hospital can't reach the first person that you've designated, we want them to have somebody else to call. We can't just wait for somebody to get back from vacation to decide whether or not you should be on a ventilator. So your patient advocate designation is your medical decision maker. You're telling your advocate what you want them to do, but unlike a living will, you can't make them do it. So you're telling them what you think you want based on your present circumstances, and then when the time comes, they get to talk to your doctor and they get to hear about the different alternatives and make the best decision for you at that time. The HIPAA waiver is saying who can talk to your doctors. So let's say you have 5 kids. Maybe you only want 2 kids to be named as your patient advocates, but you want all 5 to be able to talk to your doctors and get information. You would put all 5 on your HIPAA waiver. You might also put a friend who drives you to doctor appointments on the HIPAA waiver so that that person can talk to the doctor, find out what time the appointments are, things like that, without having to have you on the phone. The appointment of guardian is really important for you only if you have an adult child with special needs. If you had minor children, of course, you also need to appoint a guardian, but you do have the ability in your will to appoint a guardian if you do have an adult child with special needs as well. The court should have appointed a backup guardian if you have been appointed by the court as guardian, but not every adult child with special needs needs a guardian. So you can do that in your will. And then the funeral representative designation we talked about too. That's who would make your funeral and burial decisions for you. What do you need? Do you need a will? Do you need a trust? So many people call me and say, well, my mom's estate isn't going to need to go through probate because she has a will. That's opposite of true. So a will is not even valid until it's admitted to probate. So if you have that money that you want to leave to your grandchildren who are minors, or your kids aren't all that responsible, or one of the kids might divorce, and you want to avoid probate, then you should think about a trust. So you can avoid probate without a trust by doing all the beneficiary designations that we talked about. So, designating on the bank accounts, designating on brokerage accounts, the life insurance, the IRAs, and doing the enhanced life estate deed. But if you want to leave things to a lot of people, if you've got some special needs issues, if somebody's not good with money and needs to have it distributed over time, that's when you really need to think about a trust. So a lot of my clients have questions about trusts. A lot of people, especially if they did their trusts during the 1990s or the early 2000s, maybe had two trusts. So there was a spouse for a trust for the husband and a trust for the wife, and then they broke into marital trusts and they broke into family trusts. Sometimes you just need the one trust. So there are times when two trusts make sense, even for a married couple, and that would be if you have kept your assets separately, or if you've got an inheritance that you really want to go to your children and you don't want that inheritance to go to your spouse. So if I mean by that, something you inherited from another person. If you have more than 6 million combined, then I think we do need to consider now doing the two separate trusts and breaking it apart with our uncertainty as to where the estate tax exemption is going. And then, do you have any special needs beneficiaries? So a special needs beneficiary might need their own separate trust. So you and your spouse might have a joint trust that holds all your assets, but your joint trust might say, upon our death, the share for our child with special needs is going to go to this other separate trust that's a whole nother document that's just for your child with special needs. Most of my clients do have joint trusts now. So with the estate tax exemption being so high, and if you do have all the same kids and if you want everything to go in the same way, then a joint trust works for most people and it is simple, but there are still reasons for having two separate trusts. The special needs trust is important if you do have a beneficiary with autism or a beneficiary who's getting government benefits. It can really even be for a beneficiary who you just think has some problems. Maybe they have an alcohol problem and you just want to be sure that the distributions to them are being delayed. Maybe they aren't likely to ever get government benefits. A special needs trust is generally purely discretionary trust, which means that the trustee never has to distribute anything to the beneficiary. So it'll say something like that the trustee can distribute all of the trust to the beneficiary at any time or might not distribute anything. And so the trustee is authorized to pay for whatever it is that the beneficiary needs. And the trustee is also authorized to make distributions as appropriate, but the trustee never has to give money to the beneficiary or even to the beneficiary's creditors. So the special needs trust, it would be a third-party trust if it's being set up by you for the benefit of somebody else. If the beneficiary inherits and then we need to scramble to set up a special needs trust, that can be done too, but then the remainder beneficiary has to be the state. So by setting up the special needs trust in advance, you can say who the backup beneficiary will be. So you could say, when my child with special needs dies, if there's still assets in the trust, I want the remaining balance to go to the ARC, or I want the remaining balance to go to my other children. So you can set up all of the backup plans. And by having the separate trust, then you can tell your other family members. So, a common problem is that an aunt or uncle or a grandparent knows that there's a special needs beneficiary and is just trying to be helpful and leaves money to that beneficiary. But it's just so much that the beneficiary gets disqualified from the benefits that they really need. So by having that special needs trust already set up, other family members can also direct their bequests to the beneficiary to that trust. And you may not need a special needs trust anymore. We have an act that's also newish called ABLE, and this is now in every state. It's under 529 of the IRS code, which is also the College Savings Plan section. So ABLE is Achieving a Better Life Experience Act. And what that is it lets you set up an account for a special needs beneficiary. And there are restrictions about how old the beneficiary has to be when the account is set up or when the disability was recognized. And then the beneficiary is allowed to contribute themselves to the ABLE account, and other people are allowed to contribute too. There are limits on how much can be put in each year. It's $15,000 if it's gift. If the beneficiary is putting their earnings in, then it gets a little bit higher. And that can be a way of letting them save money to buy a car, or save money to go to Disney World, or save money for a special thing. It caps out, so you don't want to put a ton of money in there, and it doesn't completely take the place of the special needs trust because of the limits on the assets. And also whatever is left in the ABLE account when the beneficiary dies has to go to repay Medicaid benefits. So it's, you know, that's another downside to ABLE as opposed to the special needs trust. These are the powers of attorney that we've talked about, and I really talked about most of these when I was on the page about all the documents that you need. So the general durable power of attorneys first, and that's the most important document you should have. The springing durable power of attorney, if you're not sure you want someone to have access to your assets right now, but you want them to be able to help you if you need it. The living will, as we've talked about, is not valid in Michigan. You may need a living will, though, if you have a vacation property in just about any other state. So there's only 3 states that are not living will states. Michigan is one of them. And so it's perfectly fine for you to have a living will if you have a property in Florida that you spend the winter at, and still have a patient advocate designation for the time that you're in Michigan. The HIPAA waiver is to authorize people to talk to your doctors, and then the funeral representative designations authorizing someone to make funeral and burial decisions for you. Your tough decisions. These are the things that make it really hard for my clients to decide, and they can be paralyzing. So you want to think about who you would want to be in charge of your estate as either the personal representative or the trustee. This person should be good at managing money and should be fair and should be somebody who you trust to follow the rules that you set up in your trust and in your will. It can cause conflict between kids. And if you think that your kids would have an issue with one person being named as the trustee and not somebody else, you might want to consider naming a sibling instead of naming one of the kids. It is okay to name 2 people as a trustee or personal representative, but if you have 4 kids, you don't want to name all 4 of the kids, especially if the reason that you want to name all 4 is because you think they won't get along, because they're not going to get along any better if they all have the authority either. You also need to decide who you want to make medical decisions for you. This is a completely different skill set. So maybe you've got one child who's great at managing money, but maybe your sister is a nurse, or you've got a daughter-in-law who is a doctor. Maybe that person's your best medical decision maker, even if you wouldn't want them managing your assets. And that's fine, because your medical decision maker and your trustee are 2 different jobs. But no matter what, for both of those, you want to name a backup. Who are your beneficiaries? If you've got children, that might be easier, because you might just say, I'll give it all to the kids. And if they're not alive, to their children. My clients who don't have children of their own have the hardest time with this, because you've got to think about who the beneficiaries will be. And will it be family members? Will it be charities? Will it be friends? And there's not a right answer or a one-size-fits-all answer. You've got to really think. And my question next is always, well, what if that person dies? Do you want for their share to go to their children? Do you want for their share to go among the other people that you're naming in this paragraph? You always want to have a backup. Who's the disaster beneficiary? So if all of the beneficiaries who you've named in your documents were to die before you, if there was to be a plane crash or a cruise ship sinks and your whole family's on the cruise, who do you want to get your assets at that point? And that might be charities, it might be siblings, nieces and nephews. They're probably never going to get anything, but you want to have that backup plan just in case. And then lastly, second marriage choices. This can be really hard. So if you're in a second marriage and you've got a joint trust, you might be saying that everything goes equally to all of our kids. But if one of you dies, are your kids going to maintain that same relationship with the step parent that they had while you were alive? Probably not, because you were really the glue that held them together. So then the beneficiaries might change over time and your kids might be omitted. So you want to think about, does it make sense to have just one trust if you're in a second marriage? Prenuptial agreements. This may surprise you, but most of my prenuptial clients are in their 60s, 70s, 80s, and they're remarrying when they have adult children. They've already had their assets. Maybe they've already even inherited from a deceased spouse. But this is when most of my clients are signing prenuptial agreements. And it's really about keeping assets separate. It does reassure your adult children. It reduces the uncertainty of what's going to happen. And so it's generally a good thing. It's a way of spelling out what it is that you think is going to happen, so that if one of you passes or if you did divorce, you know that what you brought into the marriage is going to stay yours, or that the house will be sold and it'll go to both of you. You can plan anything that you want. But unfortunately, at least in Michigan, a prenuptial agreement does not help if your spouse needs Medicaid. And so if your spouse were to enter a nursing home and need Medicaid, even if you had a prenuptial agreement that says, I brought all this stuff in, this doesn't go to him, still your spouse wouldn't qualify for Medicaid until your couple assets are spent down to a certain level. So I've got, I want to talk about Hyatt. I'm trying to stop at about 12 so that we have some time for questions too. So let me get through these last two. I might have some time to touch on Medicaid in a minute. The Hyatt legal plan. So Chuck talked about that for a second at the beginning. It's also called MetLife Legal now. I think they're trying to transition to MetLife Legal, but everyone still calls it Hyatt. It is available to you as a Chrysler retiree, and it covers just about everything that you need for your estate plan. So it covers your wills, it covers most trusts. So if the estate tax exemption does go down, then the more tax planning that you need, the more that you may actually need to pay for a trust, even if you do have Hyatt. If we do need to do tax planning, most of my clients don't need to do tax planning now with the exemption so high. It covers your powers of attorney, your deeds for real estate. It does cover deeds for second homes or your child's home if you own that, but it doesn't cover rental properties. It's also really good for sale of real estate by owner if you're thinking of selling your house and you don't want to use a broker. The Hyatt coverage is good for that, and it covers prenuptial agreements. It also covers, well, it covers a whole lot of things, but I just wanted to point out that the things that are only sort of covered are like probate, divorce, elder law, consumer disputes. These things have limits, like probate is 10% reduction in the hourly rate. So it's not as good for those things. I maybe wouldn't sign up for it just for those things, but you should take advantage of it. Also, I had mentioned at the beginning that I'm being a Michigan attorney and I can only give you advice about Michigan law. If you've got the MetLife Legal, you can call the attorneys there as much as you want. So it's just a phone consultation. So you can call your attorney in Illinois or your attorney in North Carolina and find out, will this work? And that's covered by Hyatt. So Hyatt can refer you to attorneys near you who are able to answer your questions, even if you don't think that you need to do new documents. So keep that in mind too. These are some resources that Chuck informed me about through your Chrysler Retirement Organization. And so there's a couple different pamphlets. I just put the first page of each one up that give you information about what's helpful to do if a spouse dies. And it sort of gives you a step-by-step procedure on what you should be doing. Okay, real quick on Medicaid. I'm just going to touch here. In Michigan, Medicaid exempt assets are your house, but it must be in your own name and not in a trust. That's why that enhanced life estate deed is helpful. Your car, but only one. It could be a mobile home. Your household goods or personal goods, all of your personal belongings, even your rings and jewelry. Prepaid funeral and burial arrangements, they have to be irrevocable. And then unavailable assets, which could be some jointly held assets. So the unavailable assets that was more important during the recession, where maybe you had a piece of property up in Traverse City and it had been for sale for a year, but nobody would buy it, but you can't use land to pay for your nursing home care. So it was possible, and it still is possible, to qualify for Medicaid if you've got assets that aren't available or can't be sold. But it's hard to show that. So Medicaid's going to be very scrutinizing of that claim. During 2020, if you are married, the community spouse, which is the spouse who's not in the nursing home, can keep up to a maximum of $128,640 in countable assets, or half the value of the countable assets, whichever is less, down to a minimum of $25,000. What that means is that if you have $300,000 in countable assets, so not your house, not your car, but your brokerage account or your IRA, your spouse who's not in the nursing home can keep $128,640 of that. And then the other part, so the other roughly 170 would have to be spent down before the nursing home spouse would qualify for Medicaid. And that could be spent down by paying off a mortgage. It could be spent down by buying another car. It could be spent down by making improvements to the house. So there are ways to spend it down without disqualifying you. You can't just give it to your kids. So if you are just making gifts, those are going to count against you for 5 years. And that's called a divestment. So when you apply for Medicaid, there's a 5-year look back where they're going to look back and see, did you give anything away in the last 5 years? They will consider gifts to your church. They will consider gifts that you made even though you had no idea you were going to be applying for Medicaid. You can qualify for Medicaid if you can show that the gifts were made without any intention of qualifying for Medicaid, but that's, again, very hard to show, and there would just be a lot of questions about that. When I say that the divestment divisor is now $8,618, what that means is if you gave one of your kids $100,000 and it's only been 3 years, then your divestment divisor is 8,618. So they're going to divide that 100,000 by 8,618 and tell you how many months you don't qualify for Medicaid for. So you'd have, about 10 months that you wouldn't qualify for Medicaid if that was the case. So I think that is about it. But yes, making gifts without consulting an attorney is not recommended for Medicaid reasons. All right, so that is the end of my presentation, and I understand there's going to be some questions. There we go.
Okay.
Of Michigan, had a will and trust created there, and now we're residents of Florida. Are our wills and trusts valid? Yes, your wills and trusts are still valid. The issue, however, is that if something came up, so if somebody was going to contest your trust, or if they weren't really sure what you meant when you said something in your trust, your will and your trust are going to say that Michigan law controls. So if you were going through probate in Florida, or if there was a dispute in Florida about your trust, that court down in Florida would have to look to Michigan law. So it would be a good idea to have your documents reviewed by a Florida attorney and possibly have them updated to reflect Florida law. Additionally, I know Florida in particular has some requirements that have to be in your trust if your house is going to be treated as a homestead if it's owned by your trust. So you should double check on that. Okay, so this is just saying that the reminder sent an hour ago included a link to the presentation, so you can find that there. Can I consult an attorney on behalf of my father who has dementia if I have a POA that allows me to act for him? Specifically, will this work if my father is covered by the Chrysler plan? Will an attorney talk to me on his behalf without his involvement? It's a little bit tricky. We would want to see the power of attorney and make sure that it authorizes you to consult with an attorney on behalf of your father. Whether it's covered under the Chrysler plan, it should be covered. It would probably be considered elder law under his plan. It could also be covered under your plan if you had it, if you were consulting about your father as an elder law review. What's the difference between estate tax and inheritance tax? Who pays is the difference. So the estate tax is paid from the estate before distributions are made to the beneficiaries. Inheritance taxes are paid by the beneficiaries once they inherit. So federally, we don't have an inheritance tax. And in Michigan, we don't have a specific Michigan estate tax or inheritance tax. But some of your beneficiaries who live in other states may have inheritance taxes that they have to pay based on the amount of money that they inherit. Can a person inheriting an IRA wait until year 10 and take the entire amount? Absolutely, they can. The issue then is that they would have to pay all the taxes in year 10. But that's a great strategy for a Roth. So if you have a Roth IRA, the same 10-year stretch is now going to apply, but you can wait and take the entire Roth in the 10th year so that it continues to grow until then. If the joint trust names children as inheritors, can the trust also spell out specific amounts or percentages for the grandchildren? Yeah, absolutely, absolutely. So either it could be percentages or specific amounts. It's completely up to you. Are people who are currently taking RMDs from an inherited IRA grandfathered? Yes. Or under the Secure Act, do they lose? No. And so it's all about who died in 2019 versus 2020. So anybody who died in 2019 or earlier, you can be taking the inherited IRA over longer, even if you didn't make that election until 2020. Secure governs people who died in 2020 or later. When you say IRA, does this include Roth IRAs? Probably. I don't know what I was referring to, but with regard to Secure, yes, the distributions have to be taken over 10 years from Roths also. In greater detail, what's meant by an enhanced life estate deed? An enhanced life estate deed, it's also called a ladybird deed. You could call it a transfer on death deed. What it is you are deeding the property from yourself to yourself, and you're reserving under the Michigan Land Title Acts the ability to mortgage the property, sell the property, do whatever you want with it during your lifetime. But then you're saying that upon your death, you want that property to go to a certain person or to a trust. So it's basically a transfer on death deed. Is it a bad idea to have all financial assets in a revocable trust versus in individual names with a POD to the trust? No, it's great to have everything in a revocable trust. The main reason that people make things payable on death to the trust instead of owned by the trust is that they think it's too much hassle to transfer it to the trust during their lifetime. Or like, for instance, if you had a separate brokerage account but a joint trust, you might want your separate brokerage account to transfer on death to the joint trust so that you get the full step up in cost basis. This is a funny question. Should the personal residence be titled in the name of the trust, or will a quitclaim deed be sufficient? Well, you can quitclaim deed the property to the trust. We are recommending the enhanced life estate deeds just about all the time now. And the reason that is that if you quitclaim deed the property to the trust, but then you need Medicaid, the house will count against you. And it's just a really dumb rule, but your house for qualifying for Medicaid counts against you if it's in the name of the trust and doesn't count against you if it's in your own name. However, you also want to avoid estate recovery for Medicaid, because if your house is in your own name but then goes through probate, then your probate estate has to pay back Medicaid for the benefits that you received. So I'm afraid that you're asking in here whether you should add kids to the property via quitclaim deed instead of transferring it to the trust. If you add your kids to the property on a quitclaim deed, they own the property when you sign the deed, not when you die. So just be aware of that. It's one thing to add your kids as joint owners to the property, which I don't recommend, but it's even worse if your quitclaim deed says that I'm hereby deeding my property from me to my kids and you're not a joint owner, because then your local assessor can go back and reassess your property and you would lose your principal residence exemption for all the years that your kids have been the owners of the property and you haven't, if you claimed your principal residence exemption, but you signed a quitclaim deed giving the property to your kids. Is a notarized document unique? That is, can a copy of a notarized be used for financial medical purposes? So under Michigan's power of attorney laws for both financial and medical, it's clear that photocopies are fine. So I think that that's what you're asking, whether you need to present the actual original every time. Some banks are going to say that they want to see the original document, but they're really just being difficult. The statute says that photocopies are fine. And now, especially with COVID, more people are accepting scanned versions. What about inheritance from a foreign country? Used not to be taxable in the United States, still true, any amount. I don't know. I'm not aware of an inheritance from a foreign country being taxable. I think, you know, obviously you have to look to the foreign country. And there may be different laws about bringing assets from a foreign country into the United States. I don't know. Please clarify why you need 2 trusts if you have more than 6 million. Well, you truly don't. So, I mean, don't forget that the estate tax exemption right now is still 11.58, and it may never go down. So it's scheduled to go down at the end of 2025. It may go down with Joe Biden being president, because his tax plan has said that he wants the estate tax exemption to go down. The reason for having 2 trusts, if you are near or over the estate tax exemption, is that you can say in your trust that any amount, the maximum amount that can pass tax-free, goes to a family trust for the benefit of your kids or your spouse or both, and everything over and above that amount goes to your marital trust. When you have a separate trust and you put part into your family trust for the benefit of your spouse, that part is not taxed again when your spouse dies. So if you just left, if you had let's say you have 3 million and your spouse has 3 million, and when you die, the exemption's 11 million, but when your spouse dies, the exemption's only 5.5 million. Because you left your 3 million to your spouse, she's gonna then have more than the taxable amount, the tax exempt amount on her death. So an estate tax would be due. If you had instead put that into a family trust for her benefit, it wouldn't be taxable again on her death. So there's nothing magic about 6 million right now. we're just guessing, and I think it has a lot to do with how tax adverse you are. If you are very tax adverse and you would never want to pay taxes, then you should consider having 2 trusts at $6 million. If you're willing to take that chance, then I think you're fine, and you would be fine with a joint trust. Is Ohio a state that requires a living will? No state requires a living will. So a living will is more than we have in Michigan. So what a living will is it's an agreement between you and your doctor. And if your agent said, I don't want to take my dad off life support, I want him on life support, the doctor can hold up the living will and say, no, your dad doesn't want life support. He can't, we're not putting him on. And that's stronger than what we have in Michigan. In Michigan, your agent can decide. Ohio, I believe, is a living will state. And so that just means that you can be more certain that your wishes will be followed if you don't want to be on life support. All right, I recently opened a checking and savings account at Citibank. I asked for a POD form and they said it's not possible for checking account, only the savings account. Is it possible someone's mistaken? Yes. Yeah, I think that it's possible that somebody made a mistake on that one. That doesn't make any sense. Is it best to have an individual as beneficiary of an IRA or a trust? So yes, both. So normally if you have typical adult beneficiaries, then you want them to be individually the beneficiaries of your IRA. So if you have 3 kids and they're all 30 and they have jobs and everybody's great, then yeah, you want them to be the beneficiaries. If you have any special needs beneficiaries or if you have minors as beneficiaries, then you want the IRA to go to a trust. There can be negative tax consequences if a trust inherits an IRA. It all depends on the language in the trust. And so there's certain language that needs to be in a trust to make it see through or look through so that the IRA distributions can be stretched out longer. Additionally, now we're putting more conduit language in, which is basically saying that everything that a trust gets from an IRA has to be distributed to the beneficiary within a short time of the trust receiving it. So the negative tax consequences to a trust inheriting an IRA are really when the trust inherits the IRA and doesn't distribute the income. If the trust distributes the income to the beneficiary, then the tax consequences are less significant, but sometimes a trust can't stretch for as long as an individual. And it is possible now, my understanding of Secure is that you can still have a trust limited to only stretching for 5 years, even though most beneficiaries, well, all beneficiaries can stretch for 10 years. I have beneficiaries on all my assets, a will, and a quitclaim deed for my house. Do I need anything else? Yes, you need a power of attorney, like 100%. You need a power of attorney. So the power of attorney is going to come into play if you're in the hospital and they want to discharge you to a rehab facility because you broke your hip and they want you to get some rehab, but you're on too many meds and they don't want you to sign the discharge papers. The hospital would make your kids be appointed or somebody be appointed as your guardian just to sign the papers to get you out of the hospital and then just to sign the papers to have you admitted to the nursing home for rehab. So yes, no matter what, you need a power of attorney. And we talked about the dangers with the quitclaim deed before, so be sure you're good there. Hyatt, MetLife Legal, does use of the word covered mean 100% of the cost? So for estate planning, yeah, covered means 100% of the cost, except if you're doing tax planning in your trust, or if you're we're doing deeds for rental properties. There really aren't a lot of other exceptions. You do have to pay the recording fees for your deeds. So in Michigan, actually in Oakland County and every county except Wayne, that's $30 per document. So it's not a significant cost. Wayne County is charging $15 per document plus a different per page fee. And there really aren't limits. You can go more than you go to the dentist. What are the specific title? Oh, okay. So yeah, I already talked about this one. This is in the handout. Oh, let me see. I printed it out. Here we go. The specific titles are A Guide for FCA Salaried Retirees, Spouses, and Beneficiaries for Actions to Take Following the Death of the Retiree or the Spouse, August 2020. And the other one is Guide for Families to Ensure Important Information is Available to Survivors, Actions Recommended Prior to and Following the Death of a Family Member, August 2020.
Yeah, and let me just say that those guides are available on the NCRO website, and that copies of both guides, one is if you die as a Chrysler retiree, and the other is if your cousin dies. You know, it's kind of more generic. Both of those guides were mailed to every NCRO member about a month, maybe 2 or 3 months ago. And let me put in a plug for John Kaiser. John Kaiser is the man that spearheaded this endeavor, and he just did an outstanding job. He ended up helping a few people that were beneficiaries to trying to get them through the Chrysler system, and wrote down what the problems he had, and that was the basis for the guide.
I believe I have the NCRO website in the correct area up on the screen right now, as far as where the guides are.
Yes, that's correct.
Okay, we'll get back to questions. We do have more. They just keep coming.
If you're not currently participating in the Hyatt MetLife plan, can you start? I believe that you can. You should have an open enrollment period that I think may have just ended. You know better than I do. But I feel like the Chrysler open enrollment is October, November.
Yeah, it just ended a week or so ago. So if you're a Chrysler retiree, you're going to have to wait till next late October to enroll. And they mail out a notice to you. So FCA mails out the information.
Is Diana offering a review of existing trust document with the idea of updating necessary pieces? Yeah, I do that every day. So yeah, that's something that an estate planning attorney does. What if I buy a house jointly with my daughter and her husband, and I later need to apply for Medicaid? Can they take the home assets before approving Medicare? Well, that's a tricky question. So nobody is going to take anything, and your assets don't matter for Medicare. And so they're only going to look at your assets for Medicaid. So your Medicare is absolutely fine. They're not going to consider that home for that. But if you do go into a nursing home and need Medicaid, then yes, they will consider your daughter and her husband's house, and that would count against you unless you have also lived there and you can claim it as your homestead too. The gift limit to your child per year, $15,000 now. So that's the limit for not having to file a gift tax return, and it's not just to your child. You can give $15,000 to every person you know every year. Can I put IRAs into trust? I understand the answer is no. Right, the answer is no. So your IRA can't be owned by your trust during your lifetime. Your IRA can be payable on death to your trust, but there are negative tax consequences to doing that. So it's generally better if you have all adult beneficiaries who don't have any special needs to name individuals instead of the trust. When the estate tax limit of, when will that go down? Well, it's scheduled to go down now at the end of, I believe it's at the end of 2025. Let me double check. Yeah, 2025, beginning of 2026, it's scheduled to go down to about 6 million per person. However, with Joe Biden in office, part of his tax plan is to reduce the estate tax exemption. So I don't know. He doesn't have the Senate. I'm not sure what will happen, but that's something that he was going to be working toward.
You know, we're running over quite a bit. It looks like we're down to the last question. Is that correct, Dale? Okay, there's still more.
Okay, mineral interests.
Well, I've got one more.
Okay. Do mineral interests that earn royalties have to be specifically named in the trust as an asset? Does Hyatt help to sell those interests should I want to avoid them being split between my 4 kids? They are very small because they've already been inherited. Yeah, mineral rights are such a pain. Yes, they need to be owned by your trust. They don't need to be named in your trust. So you need to contact the mineral rights company. So whoever you're getting your royalty checks from, you would contact them about how to transfer your interest into your trust. And you can in your trust that you want that interest to only go to one person. You can also sell it, but you'd have to contact the royalty company about how to sell it and what restrictions they might have on that. Yes, you can give $15,000 to a child or any other person, and your wife can also give $15,000. If you're each doing it on your own separate checks, then you don't have to file a gift tax return for that. But if all of the 30 is coming from your bank account, but your wife is consenting to the gift, then you can still do that all from your bank account, not a joint account. If your wife signs the gift tax return consenting to the gift. And so no tax would be due, but the return would be filed.
And that is the last question.
All right.
Okay, well, it's getting close to 12:30, so I think it's time to say goodbye. Well, let me reaffirm to people still listening that Dale will send out a thank you for attending. If you have questions, you can put them down there. The insurance committee will also send out a questionnaire, and if you have questions there, you can submit them. And also online, the insurance committee can take questions online. So we'll do everything we can to try to answer your questions after the fact. I certainly want to thank Diana. You've done an outstanding job, and I forgot to mention Diana as my estate planning lawyer, and I've been very happy with her work. I want to also thank Dale. I mean, Dale's the guy that's making all this happen, you know, and he's done a fine job. We appreciate his help. The insurance committee of the NCRO, there are half a dozen dedicated people there working for members. And there's 3 in particular on the aging task force that put this together. You see Stanley Chu, he's available online right now, and the other is Sherry Chelnick. So, and I also want to thank John Kaiser. I mentioned he did the senior guides, and they're well worth running copies. I ran copies for both my will and my backup will file, and then my Chrysler file, so that when I die, hopefully the kids will find something somewhere. So with that, again, we appreciate your attendance. At one point I checked and there were 132 of you that attended, and we hope you've learned a lot, and we wish you all a great day. Thank you.
Thank you.